We're still in a very depressed real estate market, and what I mean by that is there are a lot of residential and commercial property owners who are still underwater with the bank, meaning they owe more on their mortgages than they can sell the property for. And it's in this market that we've actually seen some people, such as real estate brokers, who are getting affected by this. Real estate brokers, as you know, out of the sale of a property, they only get a fraction of the purchase price. For example, let's say in a $500,000 deal, they have a 6% commission, so they would only be entitled to $30,000 of that purchase price. And with a $30,000 claim, it's very difficult for a real estate broker to be able to enforce that claim. If the seller decides to cut the real estate broker out of the deal, which they can easily do, they're only looking at a $30,000 claim to recover on, and oftentimes with the cost of paying attorneys to fight that, they just don't have the ability to do that. So I'm very excited to hear last year the North Carolina legislature joined about 30 other states in this country in enacting a commercial real estate broker lien act. This is for commercial property, so we're talking sales, office, manufacturing, industrial, research, and multifamily buildings that have 5 or more dwelling units. There are probably 3 situations that you need to be concerned, the real estate broker needs to be concerned about as far as timing for the filing of the notice of lien. There's very specific notice and timing requirements, so I would highly encourage a broker who's interested in pursuing a lien to get an attorney such as Shipman and Wright to help you through this process. The 3 situations that I'm thinking of as far as timing goes is in the situation where the property is being sold outright to a potential buyer. The notice of lien needs to be filed with the clerk of Superior Court before the property is conveyed. If it's a commercial leasing situation where the broker has procured a tenant, the notice of lien needs to be filed within 90 days after the tenant has taken possession of the property. And there's a third situation which is not as common. It's where the written commission agreements provides for a certain date at which the broker gets a commission. It would be after a conveyance of property or after a leasing situation, but it's just a certain like a date set. In that situation, the broker would still have a lien right, but they need to file their notice of lien within 60 days of the date required under the commission agreement. And like I said, there's very specific notice requirements. You have to give notice to the owner. This is where it's easy to mess up, so definitely go see an attorney. The one thing about this lien act, it is for commercial real estate. Unfortunately, there's only 3 states in the country that have residential real estate lien acts, and North Carolina is not one of them. But certainly this lien act does provide a lot of protection for brokers. Particularly once you file that notice of lien, you have 18 months before you have to what they call perfect the lien, to further enforce and perfect your rights. You get within that 18th month time period. After that time period, you have to file your lawsuit, which of course you probably should go see an attorney to bring your lawsuit in Superior Court. That 18 months allows time to negotiate with the seller, whereas before, when you didn't have a lien right, the broker was on a very uneven playing ground and probably wouldn't get the time of day if all it was with a $30,000 commission agreement. So it's a great new law, and I'm glad to see that North Carolina is moving along with 30 other states in the country. And if there's brokers out there who are finding themselves harmed, I definitely encourage them to come to Shipman and Wright, or find an attorney to help you.